state your first name and last name for the record and spell them both.
Anas Aldasuki, Anas Aldasouqi.
All right, please raise your right hand. Find the oath. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so help you God, or under the penalty of perjury?
Yes, God willing.
Thank you. All right. So just let me know if I get a little fast, all right?
Sure.
Okay.
Thank you.
So we're on the record in 2403140.
هذا رقم القضية.
Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Blackman.
Fred Blackman on behalf of Mr. E.P.
هذا اسمه.
And you are safe as, is that correct?
Yes, sir.
All right. This is the time set for a probable cause conference.
هذا الوقت اللي حددناه عشان اللي بيسموه probable cause.
And Ms. Wilson, how are we proceeding?
Your Honor, I believe Mr. Blackman is starting a homicide trial tomorrow. That's going to go into next week. So I believe there's going to be a waiver of the 21 days, and I think we have a date of December 5th.
Is that a fair statement, Mr. Blackman?
It is, we've set the, we're not another PCC,
Mhm.
but we've set the preliminary exam
All right.
for December 5th at 10 o'clock.
May I inquire of your client of his waiver of the 21-day rule?
Yes.
So you set the new date already?
We've set the date, with a new date for December 5th.
So March 14th, December 14th.
No, December 5th.
Yeah.
At 10 o'clock.
All right. So, Mr. As, you understand you have a right to a preliminary examination today.
تعرف إن عندك الحق للفحص التبديلي اليوم.
A preliminary examination is a probable cause hearing
وهذا معناه فحص تمهيدي شوف إذا في دليل يعني.
in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime.
وإنه يعني الناس لازم يثبتوا إنه في جريمة حصلت ويواجه الدليل تبعها.
You are represented today by Attorney Fred Blackman,
المحامي تبعك فريد بلاكمان.
and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan.
المفروض يكون موجود عشان يتكلم مع أي شهداء. شهود.
It is my understanding it is your wish today to waive your right to a prelim only within that 21-day period. All right, and waive your so you would be having a prelim. You'd only be waiving your right to it within 21 days.
لسه راح يكون عندك الفحص التمهيدي بس مش بأول 21 يوم.
And the reason being that Mr. Blackman's in trial, and so we're going to set it out past the 21-day period so he can zealously represent you.
السبب إن المحامي تبعك عنده قضية الآن يعني وانتظر وقته.
Is your wish today to waive your right to a preliminary examination within 21 days?
Yes.
Yes, okay. So I find the waiver of the 21-day to be knowing, voluntarily, and accurately made. And I'll indicate that the defendant waived the 21-day rule. And we will reset, and you're gonna have to give me that again.
December 5th at 10.
December 5th at
10 o'clock.
10 o'clock, all right. So with the waiver of the 10-day rule, or 21-day rule, we've reset it for December 5th at 10 o'clock.
12 يوم 5 على الساعة 10.
Anything else for the record in 2403-140? Ms. Wilson?
I can't remember if the court asked, but people also waive their 21 days.
People also waive the right. to
Other than
quit.
that, nothing further.
All right. Anything else for the record, Mr. Black?
No, thank you.
All right, you should be all set. Thank you for your assistance today.
Thank you. Oh, no problem. No problem.
Mr. Palmer and his client weren't here, and they were hoping to go next, so I'm just gonna pop.
All right, you're gonna-
Sign my
Still
form.
around.
I can, if you have it on.
Right?
Yeah, yep.
Yeah.
Yes.
No.
Mr. Palmer, are you ready on
Dragging a little bit, but
Mr.
we're
Wilson?
getting
I am, Judge, thank
there. It's
you.
Friday.
Yeah. You guys are so busy today. Hopefully,
That's David Wilson.
that is correct, Judge.
It's barely easy day.
How was my interpretation there?
Good.
Yeah, I'm a little bit slow sometimes, but.
All right, so we're on the record in docket 24025523. That is People of the State of Michigan versus David Wilson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Palmer.
Thank you. Your Honor. Robert Palmer of the Public Defender's Office on behalf of David Wilson, the gentleman who stands to my right.
And sir, you are David Wilson, is that correct?
Yes, sir.
All right, thank you. This is the time set for a contempt hearing concerning a violation. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that Mr. Wilson will be pleading to the violations.
And I want to make sure, because if I have several violations,
So once we have our GPS zone violation.
those are the ones
And I
I,
believe there are 3 total.
That's also my understanding, Judge. I believe there should be one from September 1st, one from September 15th, and one from October 3rd.
okay. That is September 1st, September 15th, and October 1st,
October 3rd.
Third.
Judge.
October 1st.
Yeah. Thank
And is that your understanding, Ms. Wilson?
Yes, it is.
All right. Mr. Wilson, you understand you have a right to a hearing in this matter. You are represented today by Attorney Robert Palmer, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
It's my understanding it is your wish to plead to the violation of a violation of tether concerning this matter and then proceed to allocution. Is that your understanding?
Yes, sir.
Is that your understanding, Mr. Palmer?
It is.
All right. So let's go back. We'll go back to please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
There was an exclusion zone set on your GPS tether. Is that correct, sir?
Yes, sir.
And on September 1st, September 15th, and October 3rd, I have you drove through the exclusion zone and in violation of your bond condition. Is that correct?
Yes, sir.
All right. I want to make sure that, so on October 3rd, you drove through the exclusion zone. I have for about a couple minutes or a minute.
1 minute. Yeah. That's what I have, Judge.
I have on September 15th, it was 3 minutes
Yep.
Correct.
through the exclusion zone. And then on September 1st, it was 2 minutes on the exclusion zone.
That's exactly what I
All
have,
right.
Judge, as well.
All right. Anything towards a factual basis for violating the exclusion zone, Ms. Wilson?
People are satisfied.
Mr. Palmer?
Also said so.
All right, allocution, Mr. Palmer, and then I'll go to Ms. Wilson.
Thank you, Judge. As the court can see, that all 3 of these are violations for what appears to be a drive-through of an exclusion zone. There's no allegation that he had contact with any protected person. I will point out, Judge, not that this is an excuse, but I will point out that I think on the first one, that is the September 1st one, that's the one that's next to her home. Mr. Wilson and I spoke about it. He was trying to go to Kroger that day. He drove down and you can kind of track his progress. He drove down to Holmes. He crossed Holmes thinking it was far enough south. It turns out to not be. And the tether went off and he certainly made a mistake. The other two appear to be not for her home, but for her workplace, which is on Saginaw. So it's kind of a main artery through town. Again, when we look at the one on September 15th, you can see he's driving south, he's heading northbound. He skirts into that exclusion zone by maybe 50 feet, just barely into that exclusion zone. And again, I think he was trying to be mindful of that and again, kind of lost track of where it was. The third one, as I understand that, that's the October 3rd one. He was going to a mechanic shop, passed through. To be clear, Judge, Mr. Wilson doesn't make any excuses for these. He understands he's violated the zone. He was, I think, trying to be in compliance, kind of lost track of things. And, you know, I would ask that the court give him a stern warning, but I think that Mr. Wilson appears to be on track otherwise. I am going to provide him again today with a copy of these documents so that there's a clear map. I've also instructed or intend to instruct Mr. Wilson that if he has any concerns about where that exclusion zone is specifically, that we can try to obtain another map for him from JSG so that he can be very mindful of these exclusion zones. But I would ask the court warn him and not hold him in further.
All right, thank you. Ms. Wilson.
Thank you, Your Honor. I know the complaining witness is present today. I'm not sure if she has anything she wants to say. No? Okay. As far as the people, their position on this, Your Honor, largely leaving it to the discretion of the court with the understanding that now we know pretty clearly where the exclusion zone is, so future violations are going to be taken a bit more seriously.
Thank you. Mr. Wilson, this is a stalking case, so you know the magnifying glass is on you. And you're not a kid, and I'm not going to treat you like a kid, all right? You know the rules and the parameters. If there's another violation, I'm just going to assume that you're violating the order, and then I'm running out of options, and that's when I'm going to decide, you know, where to put you. And so I'm going to assume it's not a problem anymore. This is a learning point, but you understand that we don't have anywhere to go here. All right, Mr. Palmer, thank you. If you provide him with any of the exclusion zones, he's now on notice that it's all here, and we'll take this as the learning point. But it's also stepping off. It's also stepping off point. It's so because I'm simply running out of options on the stocking case. So that's my warning. All right. Next time there won't be a warning. It'll just be it'll be an easy thing to do to eliminate any options. But you seem to know what the exclusion zone is, and I don't think anything needs to be further said on that. Okay. All right. Anything else? So that's my warning. I'm going for the violation of exclusion zone. And anything else on the record in 2402-523, Ms. Wilson?
Not for the people.
Mr. Palmer. All right, you're all set, Mr. Wilson. Thank you for your appearance today.
All right, thank you, Judge.
Yeah, perfect. Thank you. Thank you. And then I believe, Mr. Howard has disappeared.
A judge?
He was on.
Yeah.
Mr. Mataloni, what case are you here on?
I'm here on Mansell Paradia, and I have to drive from Battle Creek to Calhoun County, so I was going to ask if maybe I could go next. I think Mr. Paradia should be there.
Yeah, is he here?
I don't have him checked.
I don't have anybody. Yeah, check the hall. Is he on Zoom? No.
No, I told him to be there in person. He was going to be there at 9, so he may be running a little late. But today's the
Okay,
PCC.
he's here.
Right here.
He's here.
Yeah.
He's right here, Mr. Mataloni. So I think we can call him.
Okay.
And then, Mr. Mataloni, are you appearing on behalf of Toby White or are you newly retained?
Is it Toby White or
It's
Jamie
not,
White?
it's not Toby White, it's
It's Jamie
H.
White.
James. Yep, and I am of counsel to them, so I'm appearing on behalf of,
All right, so
Their
you're
law
on,
firm?
you're on behalf of Mr. White.
yes, sir.
All right, and you're Mr. Frieda, is that correct?
Yes, Your Honor.
All right, let me grab that file and we'll call that case. And that is a PCC.
Mhm.
All right. All right, so we're on the record in docket 24-02705. That is People, of the State of Michigan versus Mansell Parida. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Mataloni.
Mike Mataloni on behalf of Mansell Paradia, who's in the courtroom. I'm appearing via Zoom.
And sir, you are Mansell Parida, is that correct?
Pareda.
Parida, thank you. All right, this is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. My understanding is that we're going to be proceeding to an exam. I can't recall if we have an exam date or not.
We have a leave, so it's left on for preliminary examination.
We're not, the defense doesn't want to hold a preliminary exam in this matter. We would like to try to work out a deal. And I'm wondering if, Ms. Wilson can advise if they would be, in a position to offer a misdemeanor.
I
the
have
felony?
an offer, however, I have to see if the complaining witness is going to appear at the exam before I can relay it.
All right, so there's
Okay,
an
if you would-
offer, but it's based on whether the victim shows up or not.
Yes.
Okay.
And so do you want to just leave it on for the 24th then?
That today's the 24th.
Oh, today's the 24th. All right. Don't leave it on for the
Yeah, we'll
24th.
Because
we're gonna leave it
My-
on for today.
my understanding is that she's currently represented by the public defender's office on another matter. I've reached out to them to see if they can connect me with her to get some input, so I'm not causing some issues, and I haven't heard back. So at this point, I think in compliance with the Crime Victim Rights Act, I think the only thing I can do, and what I've been advised by my superiors, is to see if she appears at the prelim. If she does, discuss it with her then, and if she doesn't, then make the offer that we're gonna make.
All right, but we don't have a date for prelim, is that
That's, I
correct?
don't recall getting one.
Well, we don't have it. It was adjourned for good cause on October 17th. So the question for you, Ms. Mataloni, is, are you in line with another good cause adjournment to set it for preliminary examination, to get a preliminary examination date, or to waive the 21-day rule so we can get a time to get the preliminary examination
I
date?
don't know that we need to necessarily do either, because I think we've already done the good cause adjournment to the PCC, so the next step is the prelim. So I think we're still within that good cause.
And Mr. Mataloni, so we could adjourn for good cause to the preliminary examination. And I think we're good, at least for one adjournment to the preliminary examination. The only thing is, we'll have to check the date with your schedule.
Well, I'm looking at October 31st, which I have the morning open. And I was wondering if we could do either another PCC or a
Can you get your
PE.
subpoena done by October
I
31st?
should be able to. I can probably serve it on her and her attorney at the PD's office and see if they can give it to her as well.
So what do we have for the 31st? Does 2 o'clock work in the afternoon?
I have a preliminary exam in Clinton County at 1.
All right, that's probably gonna go in, what does the morning look like? What is packed?
1, 2, 3, 4.
Make it 11, all right.
Yeah.
So it's not 76.
We had 15 that one day, so I feel like I can crank them out.
I'm just giving Wendy a hard time, so.
We had 76 on Tuesday.
We had Tuesday, we had 76
Right, you did.
files. So.
No, you told me 10.
I know.
Well,
I'm taking part blame for some of that. Take part, only
So-
partial blame for some of that. So we'll set it for October 31st
At 8:30.
at 8:30. this is a good cause adjournment for that preliminary examination. So it's October 31st at 8:30, Mr. Mataloni, and it's a good cause adjournment, and then we'll see where we go from there. Will that work for your
Yes,
schedule? All right.
Yes, hopefully
perfect.
we can work it out on the 31st. Yes,
All right.
I'll be there.
Anything else for the record in docket 2402-705, Ms. Wilson?
Not for the people.
Mr. Mataloni?
Just let me inquire of my client, Mr. Parady, is there anything that you want the court to change or alter at this point?
Not that I can think of, sir.
All right, nothing further, Judge. I'll be there on the 31st at 8:30.
All right, thank you. Thank you, Mr. Mataloni. We'll see you on October 31st at 8:30, Mr. Predia. Thank you for your appearance today. Thank you, Your Honor.
Thank you.
We'll see you, Mr. Mataloni.
All right, thank you very much. Have a good day, everyone.
You too.
Mr. Howard's back, so I think we're ready on Pierce.
All right, Mr. Howard, you're here on Mr. Pierce, is that correct?
Yes, Your Honor.
All right,
Oh, we're not sent.
let's go ahead and call that case. Mr. Pierce is here. So we're on the record in docket 2402-767. That is People of the State of Michigan versus Supreme Pierce. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Howard.
Stephen Howard, on behalf of Mr. Pierce, who is also on Zoom. I'm appearing by Zoom.
And sir, you are Supreme Pierce, is that correct?
Yes, Your Honor.
Okay, and you can hear me all right, you can hear me all right, Mr. Pierce?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how we proceed?
I would defer.
Mr. Howard.
If we can have a breakout room for a minute, Your Honor, I believe we can settle this matter.
All right, Ms. Wilson, would you be amenable to speaking to Mr. Howard in a breakout room?
Yes.
All right. So, Mr. Howard, did you want your client in that room?
No, Your Honor.
All right. So
I
I'm going
can
to,
communicate with my client by text.
all right. So what I'm gonna put you in room 1, and then I'm gonna put the assistant prosecutor in room 1, and then we'll come back and put it on the record.
Thank you, Your Honor.
So you should get a prompt to go to room 1. All right, so we're back on the record in 24-02767. And Ms. Wilson, did you have the opportunity to speak with Mr. Howard in a breakout room?
I did, Your Honor. I believe we've reached a resolution.
All
I
right.
would defer to Mr. Howard.
Mr. Howard, how are we proceeding?
My client will be pleading guilty to use with 7411.
All right, so there's a plea to an amended count one. Count one of use. And that's the use of the ketamine.
Yes, and I'm looking, I guess I can ask our drug prosecutor.
Is that a,
Which it's currently a analog possession, but I'm not seeing an analog use. Okay. Okay. I think you told us not to. Oh, because it doesn't cut the penalty.
oh, the attempt? The
Yeah.
attempt will cut it.
But her understanding was under
It
the
doesn't?
333 codes, it doesn't.
It doesn't.
All right,
Yeah, so I think the closest is an imitation use, which is,
I can pull up my drug chart.
oh, that's a
2
civil
seconds.
fine.
so it would, so,
I have a chart. 1 second.
It's a 1 year, because I believe all the uses are a 1 year. It's just a
Right.
matter of which
finding,
one.
finding the right 1 year. All right, so Mr. Howard, let's find the right 1 year to set it at. It's 1 year and 1,000, I think.
Yes.
And there is a Killebrew agreement of,
Yep, people have no objection to no upfront jail, or there's an agreement to no upfront jail, and people have no objection to 7411 status if the defendant is eligible. In reviewing the criminal history that I have, I believe he is eligible. And I mean,
objection to 7411 status.
it's a schedule 3, so I think I figured out which one it would be. Yup. So it would be under the general use, which covers schedule 3 substances, which it appears ketamine falls under the schedule 3.
All right.
And I have
that's-
the PAC code whenever the board's
What's the
ready.
pack code?
333.74042B.
All right.
Could you repeat that,
All right.
please? 333.
So I will. So Mr. Howard, I'm going to restate the plea agreement with the PAC code. So it's an amended count one of use of
It's a general use of a controlled substance.
general use of controlled substance, which is a 1 year and or $1,000. And the PAC code is 333.7404.2B.
No point, just to be.
Oh, just 2B.
Yeah.
So no point, just 2B. I have also that there's a Killebrew agreement between the lawyers of no upfront jail, and there will be no objection to 7411 status if Mr. Pierce is eligible. Is that your understanding of the plea agreement, Mr. Howard?
That is a true and accurate statement, Your Honor.
All right. May I inquire of your client, Mr. Pierce, of his advice of rights on the misdemeanor plea?
Yes, Your Honor.
All right. Mr. Pierce, you understand you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Stephen Howard, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. Do you understand your jury trial rights in this misdemeanor plea?
Yes, Your Honor.
All right, thank you. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the records or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be pleading guilty, since you won't be having a trial, you'll be pleading guilty to the amended count one of use of general substance or an analog substance under the 1 year and or $1,000. Is it your choice today to plead guilty to use of a general substance, or it would be a ketamine substance, on this matter?
Yes, Your Honor.
All right, I'm gonna have you raise your right hand as best you can, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, I'm gonna bring your attention, sir, back to March 13th, 2024, at the offense location of Waverly Road on Glenbrook Street in City of Lansing, Ingham County. On March 13th, 2024, were you at Waverly Road on Glenbrook Street in the City of Lansing, Ingham County?
Yes, Your Honor.
All right, and at that time, did you knowingly or intentionally use the substance of ketamine?
Yes, Your Honor.
All right, and you knew it was ketamine when you were using it, is that correct?
Yes, I did, Your Honor.
All right. Anything towards a factual basis, Ms. Wilson?
Just one, Your Honor. Mr. Pierce, you intentionally used that substance, is that correct?
Yes, I did.
The people are satisfied.
Anything towards a factual basis, Mr. Howard?
No, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. We will refer to probation for the 7411 review. So within the next 48 hours, I would say by Monday at 4, you should go to the 5th floor of the probation department. That's on the 5th floor in the City Hall of Lansing. So that's right across from the Capitol on 124 West of Michigan Avenue. And if you go to the 5th floor, they'll have the file there. And what they'll do is they'll either have an appointment there or set up an appointment for you to come in and then answer all their questions. And they'll develop a report for me. And we'll see if the 7411 status is valid. They'll also have some other questions for you. All right, sir? So you should report there by Monday by the 5th floor, and we'll set sentencing for
December 19th.
we'll set sentencing for December 19th at 8:30.
One moment, Your Honor.
All right.
I must consult the silicon god that runs my life.
Something about the calendar god that controls his life.
Your Honor, I'm in Florida.
Yeah, that's out there. Is there a date after that after the December 19th date, or one so we don't give you a bunch of dates that don't work?
Anytime, basically the next week appears to be very open.
How about the following week after that? I think the next week
The next week, Christmas.
the next week is Christmas.
So, and I think it's on our PCC in Cleveland day this year.
So that would be the day after Christmas.
And do we have that?
I don't think that's. Yeah.
Okay. Well, then I'll be there.
Does December, it would be a December 12th date or January date?
January is virtually wide open. Your
All
Honor.
right, let's do a January date. That should give them plenty of time.
Your Honor,
Yes,
in a spirit of complete candor, I'm looking at trying to get back surgery, and I'm waiting for the insurance provider and their doctor to set a date, which
all
may
right, so,
the date is unknown to me, so I have no objection to the January date. I'm just giving you a heads up.
right, that might change.
It may have to be changed. In
All
which
right,
case,
well, bring that to the court and the prosecutor's attention. We'll set it with the understanding that there may be a conflict.
yes, Your Honor, and we'll cross that bridge when we get there.
All right,
If in
So
fact
we'll set it for-
raises its head.
we'll set it for. So we'll set it for January 2nd at 8:30. And then just keep us informed if that date's gonna work for the surgery schedule. All right, Mr. Howard?
Yes, Your Honor.
So you should, Mr. Pierce, you should report to probation by Monday. And we've set this for January 2nd at 8:30 for sentencing. All right, sir?
What is the address for that, Your Honor?
The address is 124 West Michigan Avenue. That's the 5th floor of the City Hall building. And if you get up the elevator right at the 5th floor and go to your right, you'll hit the probation department.
That's all, Your Honor.
All right. Anything else for the record in 2402-767, Ms. Wilson?
Have the people.
Mr. Howard, do you have anything else?
No, Your Honor.
You're all set. Thank you for your appearance today. Mr. Pierce, we'll see you on that January 2nd date.
See you then, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Howard.
Mr. Zaney indicated that they're ready on McElroy.
Oh. Let me find. All right, Mr. Zaney, you're ready on Mr. McElroy?
We are, Your Honor. Good morning.
All right, thank you. All right, so we're on the record in docket 24-03138. That is People of the State of Michigan versus Zachary McElroy. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Zaney.
Edward Zane, on behalf of Mr. McElroy, appearing via Zoom with consent.
And sir, you are Zachary McElroy, is that correct?
Correct, Your Honor.
All right, and you can hear me all right, Mr. McElroy?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that there's a request for an adjournment from the defense. It's my understanding Mr. McElroy is prepared to waive his 21 days. And I believe Mr. Zaney indicated he's looking for a date 2 to 3 weeks out.
All right. Is that a fair statement, Mr. Zaney?
Yes, Your Honor, but I think it was 3 to 4 weeks out versus 2 to 3 weeks.
Okay. All right, so Mr. Zaney, I make inquiry of Mr. McElroy on his waiver of the 21-day rule.
You may, Your Honor. Thank you.
All right, and then we'll get a date a month out, 30 days out. Mr. McElroy, you understand you have a right to a preliminary examination, within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today and at the preliminary examination. You'll be represented by Attorney Edward Zaney, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a prelim within that 21-day period. So but you won't be waiving your right to a prelim in general, just within that 21-day period, and we'll reset it for 30 days out. So Mr. Zaney can zealously represent you in this case. Is it your wish today to waive your right to a prelim only within that 21-day period?
Yes, Your Honor.
Ms. Wilson, do the people also waive their right to a prelim within 21 days?
We do, Your Honor. Thank
All
you.
right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made, and we'll reset this prelim. Did you want to reset for PCC or for prelim?
I would defer.
Mr. Zaney.
Your Honor, I anticipate a case like this, we just go right to prelim.
That's what I figured. Yeah.
For prelim?
Yes.
Okay. So we'll reset for prelim. And we'll get a date 30 days out.
November 21st at 8:30.
November. So does November 21st at 8:30 work for your schedule, Mr. Zaney?
Just one moment, Your Honor. Yes, Your Honor.
All right. So we'll schedule it for November 21st at 8:30. Anything else for the record in 24-03138, Ms. Wilson?
Not for the people.
Mr. Zaney?
None from defense. Thank you for your time.
All right, thank you. We'll see everybody, Mr. McElroy. We'll see everybody here on November 21st at 8:30. Thank you for your appearance today.
And then, Your Honor, I believe the jail tablet is Mr. Allen. He is unrepresented. I think
All right, on the jail tablet, you can unmute.
Probably needs a jail officer.
I had
do
to
it.
mute it because there was a whole bunch of.
Right,
Yeah.
yeah, it was a good idea, but now the hard part is getting it unmuted.
Yeah.
Going out of the public defender's office. and then
Yep.
answer their questions.
I remember the email.
Okay, I just,
Yep,
I couldn't remember if I CC'd you or not.
you did. Yep.
Okay, perfect.
What is the plan from Mr. Allen?
I'm not entirely sure. It's my understanding he stormed out of his intake meeting with the PD's
Is
office.
he evaluated by cats?
I don't know. And I'm not necessarily in a position to ask for certain things, but I think if the court maybe hears from him a bit,
Yeah.
the court can make that.
He can make it on. We'll probably leave on for prelim at this point.
He was referred to cats for.
He was, okay.
I saw that. Did they evaluate him?
I don't know the answer.
I
Is
don't
there
either.
anything in the file under the RO?
No, just that he was referred to cats.
Can you put the ROA up and see if they've done that before? Sometimes reports don't die. Okay. You guys have the fingerprints. Nope.
Nothing there.
Okay. Sometimes I put the report in the file.
So let's hold off on
Yeah,
until they're
let's- yep.
able to.
Are you ready on Thomas? I mean, I don't really have an offer. It's gonna go upstairs. Okay.
Hello.
As soon as we can.
All right, Mr. Allen, stand by and we're gonna call your case in just a second. Can you hear me?
Yeah, I can hear you now, yeah.
All right. All right, Mr. Allen, we're gonna try to call your case. So we're on the record in 24-03-117. That is people of the state of Michigan versus Dudley Allen. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And sir, you are Dudley Allen, is that correct?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. And Mr. Allen, you are not represented by counsel today, is that correct?
I don't see why not.
I heard not, but I did not hear the word.
So are you represented by counsel or not?
I have not been told nothing about my case until right now. Nobody trusts me, and he put me in cell, forget about me.
Right. It's my understanding is that you were not able to finish your conversation with the public defender's office. Is that correct?
Whatever you say, I don't know, whatever.
All right. Were you evaluated by CATS, Mr. Allen?
No, and I do not need to be mentally evaluated by nobody. I have no mental illness. I've been evaluated 2 or 3 times in this city and the other city, Jackson. I pass it every time. There's no reason for that. I want to go on with the prosecution and I want probation. That's it.
All right. So, Mr. Allen, did you want this left on for preliminary examination next week?
What's that?
Is that a yes or no?
I didn't hear you.
Did you want, this is a probable cause conference to make a determination if we're leaving this on for next week. Did you want this left on for preliminary examination next week?
I want the process to go on. I want to be prosecuted for my charge.
I'm sorry, sir. I didn't understand that.
I want to be prosecuted for my charge and get this over with.
All right, you want, so did you want to talk to a lawyer?
Yeah,
So he needs to finish his PE intake then.
Yeah, so you're gonna have to finish your public defender intake to talk to a
You're
lawyer.
yelling down there. What? What'd you say? You're yelling down there. What?
But let's leave this on for preliminary examination and we'll see if a lawyer's out to talk to you. If not, we'll go from there.
I still didn't hear you.
I don't think he can hear us.
I still did not hear you.
Mr. Allen, can you
Fuck up
hear-
down there.
Mr. Allen, can you hear us?
I can't hear you.
Yeah, I can't hear
I don't
us.
think he can hear us, yeah.
Let's leave on for,
They're
so
yelling
we're gonna
down
leave
there. I
on for
cannot
preliminary
fucking hear
examination.
you.
And we'll have Mr. Allen talk to a lawyer. And if need be, after the lawyer can or can't see him, we'll decide then if maybe this is a packet material. All right.
I won't go
All
back.
right. So at this time, Mr. Allen, you're not waiving any rights and your prelim is scheduled for October 31st at 8:30. And there may or may not be somebody from the Union County Public Defender out to see you.
All right, well, I want PR bond.
All right. And so we'll require to be live in person. Okay.
I want a PR
You're all
bond.
set. Thank you, Mr. Allen.
I want a PR bond. Can I get PR bond or not? Why can I be allowed to have PR bond?
so we're on the record in docket 24-02746. That is people of the state of Michigan versus Christopher Lavoy. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Etheridge.
Morning, Your Honor. Attorney Derek Ice, also the public defender on behalf of Mr. Lavoy, who is appearing by video from the Ingham County Jail. Your Honor, I'm appearing today only for Ms. Robinson, who had a conflict and is not here.
All right, and sir, you are Christopher Lavoy, is that correct?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. It's my understanding that Mr. Lavoy, on other files that were in front of this court, was previously indicated after the evaluation that he was incompetent on those files. We actually I think we started a prelim and
We
then.
did,
Yeah.
we started 2 prelims.
And so and then he asked for the forensic packet. So at this time, I would assume we're leaving it on for prelim.
Yes, and I believe there will need to be another packet so that he can get an order on this file.
Is that your understanding, Mr. Etheridge? And I know that you're the utility player today.
Yes, Your Honor, that's my understanding, and I'll make the proper referral in our office in order to have the competency packet completed.
All right, so we'll set this, we'll leave on for prelim on October 31st, 2024 at 9 a.m. That's when the prelim date is set. And then we will garner a new packet concerning Mr. Lavoy. Ms. Robinson's the attorney of record, and we'll go from there. But this is left on for October 31st at 9 a.m. Anything else for the record in 24-02746? Ms. Wilson.
Not for the people.
Mr. Etheridge.
No, Your Honor, thank you.
All right, Mr. Lavoy, we've set it for prelim. We've left it on for prelim on October 31st, and you can talk to the assigned attorney concerning this matter. There's other files that are out there, and we have to make sure that all those are considered as part of the packet or forensic evaluation packet. All right, sir?
All right, okay.
So we've left on for prelim on October 31st at 9. It'll be next Thursday at 9 a.m. And that's all for the record in 24-02746. Thank you for your appearance today, Mr. Lavoy.
Can I get mental health in court? Well, mental health. Yeah.
All right, so, sir, you are John Gardner, is that correct?
Yes, sir.
All right, let's call your case and then we'll call Miss Wanji's case. Now, Miss Wanji, you're here on Miss Hunter?
Yes, Your Honor.
All right, we'll call Mr. Gardner's case first. So we're on the record. We're on the record in docket 24-03172. That is people of the state of Michigan versus John Gardner. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Attorney Derek Ice, also the public defender on behalf of Mr. Gardner. Mr. Gardner is appearing by video, Polycom from the Ingham County Jail.
And sir, you are John Michael Gardner, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Gardner?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're leaving this set for exam. I believe Mr. Etheridge indicated that he is still awaiting discovery on the matter. As I believe I mentioned to the court previously, we did just switch case management systems and we're currently working through some bugs in it. But I will alert our discovery unit that Mr. Etheridge has not received discovery and we'll try to get that out as soon as possible.
So I'll put on here that there may be discovery issues. She's outstanding. And that's a fair statement, Mr. Etheridge. We're just gonna leave it on at this point for October 31st at 9:30.
Yes, Your Honor, and I would just add for my client's benefit, that I did talk to the prosecutor. At this time, there is no plea offer pending consultation with the alleged victim.
All right. All right, with that understanding, Mr. Gardner, we've left on for October 31st, 2024, that for the week, for a week from today at 9:30. There may be some discovery issues outstanding. Anything else from the record on 2403-172, Ms. Wilson?
Not for the people.
Mr. Etheridge?
Your Honor, would the court entertain a motion for bond?
I will entertain a motion for bond.
Your Honor, at this time, Mr. Garner is requesting the court consider bond. Let me pull up my notes here real quick.
And Ms. Wilson, any response?
One moment, Your Honor.
Yeah, I would just, for argument, I did speak with him yesterday. He advised me that he is gainfully employed. He is a union bricklayer. He's concerned that if he remained in jail, he would lose his job. He works at Davenport Masonry, and currently working on building schools in the Diamonddale area. He's been in this area for about three to 4 months. The address he provided at the arraignment would be the address that you would be residing at.
All right, that's the West Road apartment address in East Lansing.
It's my understanding, Your Honor.
Okay. That response, Ms. Wilson?
Yes, Your Honor, thank you. These are very serious allegations, and I'm looking at Mr. Gardner's out-of-state history, and it is extensive and violent. So I am not I'm requesting that bond remained as is.
All right, I will say for the record that this is a 15-year felony, a 10-year felony, a 4-year felony in the alternative. And that this is a 4th offense notice, that there's a carjacking, a burglary, a grand theft out of Florida. So based on the nature of the offenses and the previous history, bond was set at $20,000 cash surety by Magistrate Kelly. And I'm not going to modify bond at this time. So the bond, the motion to reduce bond is denied.
Thank you, Your Honor.
Thank you, Mr. Etheridge. Anything else in the record at 2403-172, Mr. Etheridge?
No, Your Honor, thank you.
All right, Mr. Gardner, we'll see you next week at 9:30. You're all set. All right, Ms. Wanchi, we can call your case next.
Thank you, Your Honor.
Is Miss Hunter, that's Ramona Hunter? All right, you're Miss Hunter? You can come up here. Go ahead and have a seat right there, ma'am. So we're on the record in docket 2403-115. That's people of the state of Michigan versus Ramona Hunter. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wanchi.
Good morning, Your Honor. Melanie Albiwanji for Miss Hunter, who is appearing in person.
And ma'am, you are Ramona LaShawn Hunter, is that correct?
Yes, sir.
All right, thank you. This is a time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this out for exam.
And is that a fair statement, Ms. Wanchi?
It is, Your Honor. We're gonna leave it for exam.
All right, so we'll set for preliminary, we'll leave on for preliminary examination on October 31st, 2024 at 8:30. So you should, so Ms. Hunter, you should be back here on a week from today at 8:30 concerning this preliminary examination. All right, ma'am?
Yes.
Anything else for the record in 2403-115, Ms. Wilson?
That's the people.
Ms. Wanji?
Not for the defense, Your Honor. Thank you.
All right, Ms. Hunter, we'll see you next week. Thank you for your appearance.
Thank you.
Yeah, and so we'll get you notice for that too, ma'am. If you
Thank you.
stand right there, we'll get you notice.
Oh.
Is she, that arraignment that these are, but I think that.
And then I think we're ready on
Ms. Thomas?
Nathan Lone.
Wow. Yeah, thank you.
Bauman.
He is in the courtroom.
All right, perfect. All right, Mr. Etheridge. Or is that's Ms. Robinson's?
Mr. Etheridge for today.
Yes.
This is Mr. Lockman.
Lauman?
How do you say your name, sir? Logan.
Logan.
Oh, Mr. Logan. sorry.
I am close.
All right, so we're on the record in docket 24-00235. That's people of the state of Michigan versus Nathan Logan. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Morning, Attorney Derek, and also the public defender on behalf of Mr. Logan, who is seated to my right here in the courtroom. Your Honor, I'm appearing today only for Mr. Logan in Ms. Robinson's place, as she had a conflict, couldn't be here.
All right, thank you. This is the time set for a probable cause conference. And sir, you are Nathan Logan, is that correct? All right, thank you. So Ms. Wilson, how are we proceeding on the probable cause conference?
Thank you, Your Honor. I believe we're going to leave this up for exam.
We'll leave on for preliminary examination for October 31st at 9 a.m. So, Mr. Logan, you should be back here on the 6th floor of City Hall on October 31st at 9 a.m. That's a week from today, okay, sir? I think you'll get notice from my court officer on that date. Anything else for the record in 24-00235, Ms. Wilson?
Not for the people.
Mr. Etheridge?
No, Your Honor, thank you.
All right, Mr. Logan, we'll see you next week. Thank you for your hearing today.
I'll have to contact you. Put them in there. Put your concerns in there, okay?
And then I believe we're ready on Thomas.
All right, Ms. Thomas, we're going to call your case. You can unmute.
Good morning. You're welcome.
Good morning.
Good
All
morning.
right, so we're on the record in docket 24-02795. That is people of the state of Michigan versus Anisha Thomas. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Morning, Honor. Attorney Derek, that's also the public defender on behalf of Ms. Thomas. Mr. Thomas is appearing by video.
And ma'am, you are Anisha Thomas, is that correct?
Yes, sir.
And you can hear me all right, Ms. Thomas?
Yes.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding Ms. Thomas will be waiving for 21 days today. And speaking with Mr. Etheridge, there is some outstanding discovery. Again, we're changing over to a new system and we're going to try to get over as soon as possible. It's also my understanding that Ms. Thomas is in the process of retaining private counsel and needs some time to get that done.
And is that a fair statement, Mr. Etheridge?
Yes, Your Honor. Just regarding discovery, it's actually quite a bit. There's like 60 some videos, 30 or 40 photographs, initial following of around 130 pages. I did briefly meet with Ms. Thomas, discuss waiving the timeline so that she can retain. She's told me she's already met with Mr. White, has the money in order to retain him, and intends to retain him. Either way, the attorney is going to have some time to go over all that stuff. So we were asking the court to set it out 30 days, and Ms. Thomas is prepared to waive the timeline at this point. And my understanding for Ms. Thomas's benefit that there is currently no plea offer and this would have to be resolved in circuit court.
And so does Ms. Thomas plan to retain Toby White or Jamie White?
Toby White was my understanding, Your Honor.
All right, Mr. Etheridge, may I inquire of Ms. Thomas of her waiver of the 21-day rule?
Yes, Your Honor.
All right, Ms. Thomas, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Derek Etheridge, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish to waive your right to a prelim within that 21-day period and for discovery issues, and you may be retaining counsel Toby White in order to get him all the discovery issues so he can zealously represent you in your defense. Is that correct? It is your plan to waive your right to a prelim, not in general, just within that 21-day period?
Yes, sir.
All right. And the people also waive their right to a prelim within 21 days?
We do, Your Honor. Thank you.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made based on some outstanding discovery, and Ms. Thomas may be retaining a new attorney, and we'll set out 30 days, I would think.
Thank you.
So we'll set out 30 days just for review of or in that time frame.
Then it would be possible to have a PCC and a PE in case.
Yeah, we'll reset it for probable cause conference. That's a good idea.
In case Mr. White does get retained, and I understand that is her intent. She has the money to do it, so he's likely to be retained and probably want his own PCC.
So we'll set up. It'll be a probable cause conference for, and you can go further out. Be after Thanksgiving. With that.
PCC would be December 5th. If you want.
No, let's just do the December 5th date. So we'll set it for December 5th at 8:30. So, ma'am, you'll get a notification for this date sent to you, but you may want to share this with your new attorney. If you retain counsel, it's set for December 5th at 8:30. All right, ma'am?
Yes.
And that's a probable cause conference.
Thank you, Ma'am.
So you can attend that via Zoom.
Okay.
All right.
Thank you. I have a question.
Sure.
So I have to go to court again on the 31st. Do that still date, or this all going together?
That's probably a different file, I would think.
No,
Well, that was the
that's
preliminary date.
prelim.
Oh,
It has to
okay.
come back for that date.
Yeah, so you don't have to, so that prelim date has been changed. We've just reset it because you're getting a new lawyer for December 5th.
Okay.
So you're not responsible for the October 31st date.
Okay. Thank you.
All right, you're welcome. All right, so we're on the, so anything else for the record in 2402-795, Ms. Wilson?
Not for the people.
Mr. Etheridge?
No, Your Honor, thank you.
All right, Ms. Thomas, you're all set. Thank you for your appearance today.
Thank you. You have a good day.
You too.
Was Destiny Torrance brought over?
It's a good question. She should have been.
He is, he's on Zoom.
Oh.
So, Mr. Wilson, you can unmute.
Yes, sir.
All right. So we're on the record on docket 22-03338. That is people of the state of Michigan versus Samuel Wilson. This is the time set for a probation violation arraignment. And sir, you are Samuel Wilson, is that correct?
Yes, sir.
All right, this is the time set for an arraignment. I'm going to indicate to you the allegations have made against you for the probation violation arraignment. It is alleged that this was by Jody Bayless on October 9th in a request and summons for probation violation, that you violated your probation by failing to refrain from alcohol per AverHelp on September 20th, 2024. Positive results for alcohol results yielding a 18666.68 test score, and then a violation per AverHelp, a failed to test on September 17th, 2024. Mr. Wilson, do you understand the nature of the allegations that have been made against you by your probation officer?
Yes, sir.
All right, this is, you have a right to a hearing in this matter, and we are going to set this for hearing 14 days out. You also have the right to counsel. It's a little different. On the underlying file, you had the public defender's office representing you in this matter. Do you plan to seek additional representation from the public defender's office in this probation violation hearing? I would strongly recommend it.
Yes, please. Is it
All right.
court appointed?
So Mr. Wilson, this is what you're going to have to do. You're going to have to contact the public defender's office, and you'll tell them about this date. But let me give you that number so you have the number. All right.
Okay.
It's 517-679-2979, and you're gonna have to ask for representation in front of Judge Flores on a probation hearing set for
November 4th.
November 4th at 1:30 is when we're gonna set it for hearing. That should give you some time for the public defender's office to assign somebody, and then it'll be referred to this court with the name. Right now, my public defenders are John Lee and Mr. Goodrich, right?
Jacob Raleigh.
Jacob Raleigh. So, but you might get one of those names, Mr. Lee or Mr. Raleigh. They'll be representing you at the hearing on November 4th at 1:30. All right, sir?
All right, thank you.
But that they would be. You still have to call and make sure that they're going to be appointed. So you have to call that number that I gave you. All right?
Yeah.
Yes, sir. I'm gonna call them as soon as I'm off the Zoom meeting.
Perfect. All right. So we've set the formal hearing for November 4th at 1:30. Anything else? Do you have any questions of me, Mr. Wilson?
No, Your Honor.
All right. You should be all set. Thank you for your appearance today.
Thank you.
You should prioritize that calling to the public defender's office.
Okay, thank you.
You're welcome.
Bye.
Yes. That is People of the State of Michigan versus Michael Brayton. Will the parties please introduce themselves for the record? Mr. Etheridge. I'm sorry, Ms. Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Morning, Your Honor. Attorney Derek S. also for the general behalf of Mr. Brayton. Mr. Brayton is not in the courtroom.
All right, this was the time scheduled for sentencing today at 9 o'clock. It is now 10:08. It would appear that the defendant has failed to appear for sentencing. Mr. Etheridge, have you had any contact with your client?
No, Your Honor, I've had no contact with Mr. Brayton. I called the hallway for him. I believe the court officers called the hallway for him. He has not appeared. I would note that I did receive the pre-sentence report yesterday and reviewing it this morning. He also has a warrant out of 64B for a probation violation, according to the PSI.
Right. We'll have to figure out where he is. He may be incarcerated.
It's possible, yes.
Yeah, so, but he's not here for sentencing at this time, so I'll issue a bench warrant and bond forfeiture. It's immediate for his fail to appear today. And then we may hear that that he is he's otherwise incarcerated. So it's not his fault that he's not here. We just don't know where he is.
Correct.
Anything else for the record in 24022669, Ms. Wilson?
Not for the people.
Mr. Etheridge?
No, Your Honor, thank you.
All right, thank you. That's all for the record in that file. Williams and Torrance. You're gonna fill out the map.
That's what Melanie sent me, and that's what they're pleading to. There are some documents that they need to sign. Ms. Smith, do you have all the originals with you?
I haven't signed anything yet.
Okay, so
So-
Judge can just sign this.
Yeah, we need to just, Mr. Yang and Ms. Torrance and I all need to sign.
All right, and it looks like there's a plea agreement. Advice of rights.
I think it should be 5 pages total.
I'm gonna give you the packet, and then you can pick. It's like learning a bike every time.
I
There's
know,
Ride
I
a bike
know.
every time.
All right, got that.
Yeah, I saw that. She's gonna put it all around.
I'm gonna type it off.
Nope.
No, I never see him anymore. Okay, I talked to Chris Anderson. He said part of the holdup is it's with the economic crime division or whatever you wanna call it. And apparently that takes a while. I don't know. I'll call her this week and let her know that she's at least pled here, and then that way maybe that will get it moving faster over there. All right, I think we've signed
All right,
everything.
perfect.
Oh, so sorry.
I think if you please do, obviously, but we were gonna offer something else, and I think we offer, things were offered.
Fair enough.
we would check it out.
Yep.
So, I don't know.
I have Ms.
I'm gonna-
They're also just making. So I'm trying to say that we're on our docket. I was just making sure.
Yeah, perfect.
And then I'll have this, Ms. Smith, I'll have the nollies on our pieces ready for you when she leaves.
Perfect, perfect. Yes, that's perfect.
No. So, what's our choice here, so that I can make sure.
I agree.
Yeah, you still need to say that last time, but if you can email it to me, so I can have it. Yeah.
once you successfully complete any treatment, however long we decide to send you, the remaining year.
Yep.
Suspended, as long as you stay on the straight and narrow, you stay with probation, you stay sober.
I don't know
Yes.
what's going on.
We can't discriminate.
You told me there was-
That.
My
Mine
understanding
has
is.
suspended to 24 months, that's pretty standard.
Gotcha. Yeah.
And
Then I guess they had-
the probation officers will communicate with one another to make sure
I'll
that
send
you're
it
not
to you.
duplicating services.
Thank you.
things like that.
We'll see you, Mr. Etheridge.
See you.
I tried.
Thanks for covering.
Oh, no problem.
Basically.
No problem. I think I'll be back here tomorrow.
All right.
See you
Does
then.
not- This is technically,
But this is pretty.
Those are different. And
I like Robin
there's
Hood.
this amount of the restitution, and so I think that they.
I don't know what you're talking about.
Over there with each
That
other,
bench
so I
tries,
just
I
keep
just-
bothering
that
them,
was-
being like, how do you deal with this, how do you deal with this?
I think jury trial for Megan. and
We're gonna
then
get you there as soon as we can.
Two state files and then state bench trial.
Right, we gotta get you coordinating company first.
I feel bad for her.
I know.
We just-
Just keep doing what
We
you're
just
doing.
started though. We didn't
You're
finish
gonna get
feeling
there,
bad
just
for you.
Unfortunately, it's not a fast process, but we're gonna get you there, okay? Oh, this one. Okay, thank you.
Yep.
So we'll waive and then we'll plea, right?
Yes, exactly, Your Honor.
All right. All right, so we're on the record in docket 24-02104. That is People of the State of Michigan versus Destiny Torrance. This is the time set for a plea today, but it's a plea to a felony, so we're gonna waive it over first before I take the plea. Is that your understanding, Ms. Smith?
Yes, Your Honor.
Mr. Yang?
Yes, Your Honor.
All right. So Ms. Smith, I'll let you take charge of the preliminary examination. Does the defendant intend to waive the right to preliminary examination?
Yes, Your Honor, it's my understanding that the people and the defense will both unconditionally waive their right to a preliminary examination and ask that this be bound over to the circuit court. It is an unconditional waiver. However, the parties do have a plea agreement that we intend to enter today.
Right. And then this will be a plea after the waiver. Is that correct?
Correct.
All right. Is that a fair statement, Mr. Yang?
It is, Your Honor. That's a fair and accurate statement.
All right. May I inquire of your client of the waiver of the preliminary examination?
Yes, Your Honor.
It is my understanding, ma'am, you have a right to a preliminary examination today, and a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Joseph Yang, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case go to circuit court. My understanding is that today I'm going to be taking a plea on that circuit court case, but is it your wish today to waive your right to a preliminary examination?
Yes.
All right. Do the people also waive their right to a preliminary examination?
Yes, Your Honor.
Okay, I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And then I have some bind over information that I'll have the parties sign.
May I approach?
You may. I'll provide the bind over documentation to the parties. Thank you, Ms. Smith. I'm in possession of the bind over documentation for 24-02104. I'll indicate the examination has been waived on today's date, which is October 24th. Bound over as is. Is there anything else to come to the court's attention on the bind over before I sign the bind over documentation Ms. Smith?
No, Your Honor.
Mr. Yang?
Nothing from the defense, Your Honor.
All
Thank you.
right, thank you. I'll sign the bind over documentation. And then it is my understanding that the council would like the court to accept the circuit court plea from the client today. That means the plea would be entered and accepted into this court, which would be a circuit court. The case would be assigned to circuit court judge, and I believe that's Judge Dragonchuk. Is that correct?
That's correct, Your Honor.
All right. For sentencing purposes, Ms. Smith, do you consent to what I've just said?
I do, Your Honor.
Mr. Yang?
Yes, Your Honor.
All right, and then Ms. Torrance, do you consent? Essentially, I'll be taking the plea, and Judge Dragonchuk will be following whatever the sentence agreement is.
Yes, sir.
All right. I don't know if she'll follow it, but there is a sentence agreement in this case. All right. The court has already bound this matter over to circuit court. The formal information is being provided to you today. Do you have a copy of the formal information, Mr. Yang?
Yes, Your Honor.
All right. And Ms. Smith, what counts will the defendant be pleading to today?
She's going to be pleading guilty as charged, Your Honor.
All right. So you may read the pertinent parts into the record. So that's count one with the notice and the habitual offender.
That's correct,
All
Your Honor.
right. You can read that into the record.
Very good, thank you. In Circuit Court Case 24-832-FH, the people of the state of Michigan versus Destiny Caitlin Torrance. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before this court and informs the court that on or about July 15, 2024, at 500 East Edgewood Boulevard, City of Lansing, Ingham County, the defendant in count one, retail fraud first degree, did, while Target was open to the public, steal property of the store that was offered for sale at a price of $200 or more, but less than $1,000. And it further appearing that on September 7, 2023, said defendant was previously convicted of violating retail fraud second degree, MCL 750.356D in 56A District Court, Eaton County. Therefore, this violation of MCL 750.356D1 constitute retail fraud in the first degree, contrary to MCL 750.356C. This is a felony punishable by up to 5 years and/or $10,000, or 3 times the value difference in price of property stolen, obtained, or attempted to be obtained, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by the trier of fact. The court may order reimbursement to the state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution. Take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies. In that on or about March 13, 2012, she was convicted of the offense of attempt, resist, and obstructing a police officer in violation of MCL 750.81D1 in the 54A District Court for Ingham County, State of Michigan. And on or about April 5, 2023, she was convicted of the offense of resisting and obstructing police in violation of MCL 750.81D1 in the 56A District Court for Eaton County, State of Michigan. And on or about August 18th, 2023, she was convicted of the offense of retail fraud first degree in violation of MCL 750.356C in the 56th Circuit Court for Eaton County, State of Michigan. And on or about August 18th, 2023, she was convicted of the offense controlled substance possession less than 25 grams in violation of MCL 333.7403285 in the 56th Circuit Court for Eaton County, State of Michigan. Therefore, defendant is subject to the penalties provided by MCL 769.12. Penalty is life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for a first conviction. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition, if not taken at arrest. She did this against the peace and dignity of the people of the state of Michigan.
Thank you. Defendant, I'm going to have you raise your right hand. Do you swear or affirm that the information you're about to provide to this court will be the whole truth, so help you God?
Yes.
All right. The charge here is commonly referred to as retail fraud in the first degree, that is 200 to 1,000. There is a second or subsequent offense notice on that, which would raise it to a felony of 5 years. And then there's an habitual offender notice, fourth offense notice, that would raise that to a 15-year offense if I read that correctly. Is that correct, Ms. Smith?
Your Honor, it would technically be a life offense because the retail fraud first is 5 years.
Right. So the penalty of the primary offense has a penalty of 5 years or more. You're correct. So that would be a life offense. Is that correct, Mr. Yang?
Yes, Your Honor, that's my understanding.
All right. Thank you. So you understand the nature of the charges that have been brought against you. Is that correct, ma'am? Okay. And there's a maximum penalty of a life offense. Are you on probation or parole at this time?
Yes.
Okay. And where are you on probation or parole to?
Eaton County.
And to clarify for the record, Your Honor, that's probation, not parole.
Okay. If you've been convicted of a felony in the past, you could be subject to penalties as a habitual offender. You understand that, and we've talked about that today. Is that correct? Yes. All right. You have some rights in this felony plea. I'm going to walk you through those rights. All right, ma'am? You have the right to have a trial by jury, have a right to have a trial by judge, the right to be presumed innocent, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have witnesses against you appear at trial, the right to cross-examine those witnesses that are brought against you, the right to have court to order your witnesses appear in your defense. You have the right to remain silent and not have your silence used against you in any way. You have the right to testify at trial if you choose to testify. You are represented today by Attorney Joseph Yang, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan at trial. Do you understand these rights, ma'am? Yes. And is it your intent to waive these rights and plead guilty to this charge? Yes. All right. You also give up the claim the plea was the result of any promises or threats that have not been disclosed today on the record. Is that true, ma'am? Okay. You understand that you also give up the right to appeal anything from your conviction, and sentence would not be automatic. You'd have to ask for permission to appeal your conviction to the Court of Appeals, because you won't be having a trial today. Your appeal would be as to the guilty plea. Do you understand that, ma'am? All right. And then Ms. Smith, would you like to read the plea agreement into the record?
I would, Your Honor. This is a fairly detailed plea, so I will speak slowly and go thoroughly.
All right, and I do have the plea agreement with an addendum, and it's been signed by all the parties. Is that correct, Mr. Yang?
It is, Your Honor.
And Ms. Torrance, you also signed this?
Yes.
All right, go ahead, Ms. Smith.
Thank you, Your Honor. For the file that's currently in front of the court, the defendant is entering a guilty plea to count 1, including the second offense notice and the habitual fourth offender notice. In exchange for that guilty plea, several cases that are either pending review with my office or already charged with my office will be dismissed, but the defendant agrees to pay restitution on those cases, and I'll go through those in a moment. With respect to the sentencing on the underlying case that we're taking the plea for today, the parties have entered a sentencing agreement that the defendant's upfront jail shall not exceed 365 days. But any and all of that can be served in a treatment facility as designated by the court, and that the balance of any sentence remaining after successful completion of that treatment would be suspended pending compliance with probation. For the cases to be dismissed, I will go through those now. File 23-1991-SM. There is $459 of restitution to Clarkson Eyewear. This will be dismissed. In file 24-1353-SM, there is $726 restitution to Walmart. This case will be dismissed. In 24-2175-SM, there is $698.99 restitution to Target. This case will be dismissed. In case 24-2656-SM, there's $905.98 restitution to Lowe's. This case will be dismissed. I'm going to start referring by cases to their case tracking number, which is an internal number for the prosecutor's office, as these cases have not yet been charged through the court system, but have been reviewed by my office. In CTN 24-3418, there is no restitution owed. This case will be dismissed. In CTN 24-3420, $436.93 restitution to Meyer. This case will not be authorized. In CTN 24-3734, there's $552.19 restitution to Target. This case will not be authorized. In CTN 24-3828, there's $827.92 in restitution to Meyer. This case will not be authorized. In CTN 24-3890, there's $1,573.82 in restitution to Meyer. This case will not be authorized. In CTN 24-3979, there's $189.98 restitution to Meyer. This case will not be authorized. In CTN 24-4119, there's $778.96 owed to Target in restitution. This case will not be authorized. In CTN 24-4141, there's $254.95 in restitution to Meyer. This case will not be authorized. And finally, in CTN 24-4264, there's $9,938.16 in restitution to Target, and this case will not be authorized.
Is this a full and accurate statement of the plea agreement, Ms. Smith?
Yes, Your Honor.
Mr. Yang?
I've been following along, Your Honor, and yes, it is.
All right. And then Ms. Torrance, that's your understanding of the plea agreement, and you've signed the bottom of the plea agreement sheet.
Yes.
Is that correct? All right. Ms. Torrance, you are pleading guilty because you are guilty. Is that correct? All right. I've already sworn you in, so let's make a factual basis concerning the plea. And then I will indicate that this is in count one for, were you at 500 East Edgewood on July 15, 2024? That's the allegation, that you were at 500 East Edgewood on July 15, 2024. And is there a place there, or is Target there? All right. And was there property open to the general public at that Target store on that date?
Yes.
And was that property offered for sale to the general public at $200 but less than $1,000? And did you intentionally take that property without paying for it? And you knew that property was it for sale for the general public, and you intentionally took it knowing that you weren't going to pay for it?
Yes.
Right. Anything towards a factual basis on count one, Ms. Smith?
To your understanding, Ms. Torrance, that Target that you were at, is that in the city of Lansing?
Yeah.
And is that in Ingham County?
Yes.
Nothing further, thank you.
Anything towards a factual basis, Mr. Yang?
The defense is satisfied, Your
All
Honor.
right. Do you agree that it appearing that on September 7th, 2023, you were previously convicted of retail fraud in the second degree in Eaton County at the 56A District Court?
Yeah.
So with that understanding, that is the second or subsequent offense notice concerning the 5-year felony, and then I'm going to ask you about some of your habitual offenders, okay? Offender notice. Would you agree with that, Ms. Smith?
Yes, Your Honor.
Mr. Yang?
Yes, Your Honor.
All right. Would you agree with me, ma'am, that you pled guilty to attempted resisting and obstructing a police officer in violation of MCL 750 in 54A District Court in the Ingham County, State of Michigan on March 13, 2012?
Yes.
Did you plead guilty to resisting and obstructing a police in violation of 750.81 D1 in 56A District Court in Eaton County on April 5th, 2023?
Yes.
Did you plead guilty to, on August 18th, 2023, you were convicted of the offense of retail fraud in the first degree in violation of 7505356C in the 56th Circuit Court for Eaton County?
Yes.
And did you plead guilty or you were convicted of the controlled substance on August 18th, 2023, of the controlled substance of possession less than 25 grams in violation of MCL 333.7403285 in the 56th Circuit Court for Eaton County?
Yes.
All right. Therefore, this is a life offense with the habitual offender notice. That's your understanding. Is that correct, ma'am?
Yes.
Are counsel aware, Mr. Yang, of any promises, threats, or inducements for this plea other than those disclosed on the record?
No, Your Honor.
All right. Ms. Smith?
No, Your Honor.
All right. Does the council believe the court has complied with MCR 6.302 and the local administrative order allowing a felony plea in district court? Ms. Smith?
Yes, Your Honor.
Yes, Your
Mr.
Honor.
Yang?
Yes,
Thank
Your
you.
Honor.
The court would find the plea to be accurate, voluntarily, and understandingly made. The pleas accepted, and this is transferred, so the pleas accepted as charged. And this will be transferred to Judge Dragonchuk.
Your Honor, may I make a brief record?
Yes.
Just so that it's abundantly clear, because I've seen this before. Ms. Torrance, you understand that you have the right to be sentenced by the same judge that takes your plea. But because of the way we're doing this plea with asking Judge Flores to do it now so that we can speed up sentencing, you're gonna waive that and you're okay with Judge Dragonchuk sentencing you rather than Judge Flores, right? Okay, thank you, Your Honor.
All right, so so the defendant on the record is waived that Dragonchuk can do the sentencing. The Judge Dragonchuk can do the sentencing. And do we have a sentencing date yet? I don't think we do we?
We do, Your Honor. It's December 16th, 2024 at 3:30 PM.
At 3:30. And do we have a file number for circuit court?
We do, Your Honor, 24-832-FH.
All right, ma'am. So, Ms. Torrance, you heard that Judge Dragonchuk will be sentencing on December 16th at 3:30. For the file number, the circuit court file number, I would assume a pre-sentence investigation is going to be done on this.
Yes,
for
Your
that?
Honor.
All right.
Probation will meet with her either in person if she's in Ingham County Jail or by polyconference if she's in Eaton County Jail. If for whatever reason she is released completely on her own recognizance, she should report to the Circuit Court Probation Department within 24 hours of that release.
All right. Now I have the bond. Is the bond continued at this time? Ms. Smith?
Your Honor, I believe the defense has a motion regarding bond.
Okay, Mr. Yang, I get the court will entertain any motion on reduction of bond.
Thank you, Your Honor. Ms. Torrance is kind of caught in limbo right now. She was supposed to start probation in Eaton County, but has not even started that. But because she is here in Ingham County, Eaton is not coming to get her because she has a bond. Both myself as well as Ms. Smith have tried to kind of speed this along and even get her arraigned on the probation violations. We have not been successful in that. So what I'm proposing to the court is to set a PR bond for Ms. Torrance so that that'll force Eaton County to come get her. She was scheduled for 3 years of probation there. And she hasn't even started a date yet on that. And then she was in custody. And so she's kind of stuck between a rock and a hard place. I understand with her history, the court might be inclined to do like a GPS tether or something like that. Unfortunately, it kind of, again, becomes a chicken and egg problem. If the court puts a GPS requirement on there, she's not eligible to be transferred because the Ingham County can't release her without the GPS tether. And then Eaton won't come get her because she's being held at Ingham County. So she's stuck in the same place again. She has been in custody for a long time now on this matter. And for all intents and purposes, not getting any credit for Eaton County because they've not arraigned her. And we've done our best. So at this time, I'd ask for a PR bond so that Ms. Torrance can deal with the Eaton County matter. We know that's 3 years of probation out there. That's already, the sentence has already been done on that.
All right.
Your Honor.
Thank you. Ms. Smith, and comment on bond, the motion for bond. My understanding of the plea agreement that it's a year. She's got a year to do it in Ingham County under this agreement.
Under this agreement, Your Honor, the understanding is that she needs to do no more than a year in jail. However, any and all of that can be served at a treatment facility. And that is going to be a joint request by the parties at the time of sentencing. Correct me if I'm wrong, Mr. Yang. The ultimate goal here, Your Honor, is clearly there is an abundance of restitution, both in our county and in Eaton County. In order for Ms. Torrance to make those victims whole and pay that restitution, she needs to be sober and she needs to be working. So being incarcerated is not productive towards those goals. And so ultimately the people's position is that she needs to get to treatment as fast as possible. I think the only way to get her to treatment is to clear up any warrants that she has in Eaton County. And frustratingly, as Mr. Yang said, we cannot, for whatever reason, get Eaton County to request a writ for her to go there and handle her business there. So reluctantly, I am in agreement with Mr. Yang's request that she be given a PR bond and not immediately ordered to be placed on tether. However, what I would request is a specific term that if she is released from Eaton County Jail, that she has 24 hours to report to probation and be placed on a GPS tether.
Well, this is a joint request, really administratively to get any type of sentence started in Eaton County is the problem. How much time does Ms. Torrance have on this file?
How much credit does she have?
How many credit does she have?
A bit, Your Honor. I would say she's
In the realm
approaching,
of 120 days.
yeah, I would say she's approaching 4 months or right
So
around that area.
I will agree with counsel and set bond at PR 2,500. And then I will join in the request that if at the time she's released from Eaton County, she has to report back to Ingham County. And that's simply to start your time here because you got time left under the plea agreement. So you might as well start that, okay? If you don't, that violates the plea agreement and then we got a problem, all right? And that's Judge Dragonchuk's problem. That's not my problem. I'm just telling you that's where this is headed is a sentencing by Judge Dragonchuk, okay? So back to Ingham County to serve the follow-up on the 365 days. So as a part of the record of guilty plea, it says continued on bond. I'm gonna check that box with the understanding that bond's a PR bond now.
Understood, Your Honor, thank you.
2,500. And then that'll be the bond set so we can clear up any Eaton County issues. Anything else for the record on the circuit court file case, which would be, let me find it.
24832.
24832 FH, Miss Wilson, Miss Smith.
Nothing other than to just reiterate, because we've had a lot of information here to Ms. Torrance, that if for whatever reason she finds herself out of custody in both Ingham County and Eaton County, 24 hours to report to Circuit Court Probation here in Ingham, which is at 313 West Kalamazoo, in the basement. Yeah.
And you have that understanding, Mr. Yang.
I do as well, and I've given her my contact.
Ms. Torrance, what they're doing here, the lawyers have agreed to essentially make an exception in your case. So you're going to be released to Eaton County so that probation get cleaned up, but you've got a year left on this sentence, and that's not going away. It's going to be there regardless, and it may turn into a life offense if you're not careful. So be really careful. All right. I would report even if you think you need to report. All right, just to make sure, all right? All right, that's all for the record in 2402-104 and the circuit court file of 24832. Ms. Torrance, good luck to you, okay? Thank you.
Thank you, Your Honor.
Thank you, Mr. Yang.
My last day in county is gonna be in a couple weeks, okay? So there's gonna be a different prosecutor at your
We did
sentencing.
leave it all
But
up
I'm gonna be
because
doing myself on number, and if there's any problems, he's gonna call me. And whoever fills in for me is gonna do exactly what we've already talked about and exactly what we promised you, okay?
This goes.
You want me to go talk to you downstairs? I don't know if I can today, because I've got some other things that I need to do, but if I can't today, I'll come see you in the jail tomorrow. Okay? It's not gonna happen that fast. I don't think so. Do you want Mr. Yang to be there while we talk, or do you want to just talk to me? Okay, can you tell me verbally that you're okay without talking, or to talk to me without Mr. Yang?
Yeah.
Okay. It's not about that. Okay. All right, I just wanted to make sure. Black phone? Oh, yeah, that's awesome.
Do you have those nallies by chance? They're on my desk.
Sorry, yep, I'll hand them up to you.
Okay, thank you. I just try to make sure I have. all
No,
of
you're
her-
good. If you find that we missed something, just let me know and I'm happy to pop back over and sign whatever's needed, or Abby can sign in my place.
Thank you.
As long as it's nothing crazy.
Eventually, let you know right now.
Okay. I can't get back to her yet. No, she's gonna get there. I've been working with Miss Torrance since 2018.
well, good luck to you. That, I mean, but that's a hard road.
It is,
Yeah.
but this is the first time in 6 years that she's said she wants to go to rehab. Every time we've sent her before, it's been against her will. And, right, it doesn't work. You can't help somebody who doesn't want help.
Right, yeah,
So
they've invested in that process.
she finally hit rock bottom. Her mom passed away this year, who was like her last thread of support. Her kids are officially terminated and adopted, so she's finally at the point where she's like, oh, I've got nothing. I've literally
Well,
nothing.
good, that, then maybe that's what it takes.
I hope so. She's got a soft spot in my heart. Oh. Thank you. I appreciate that.
You're all set.
Thank you.
All right.
I will email you myself so that you have it. My last day is probably gonna be the 8th of November. But I'll make some calls before then. Thank you. So sorry, sir.
All right, so are we ready on Miss Williams?
Yep.
All right.
Yes, Your Honor.
All right, so we're on the record in docket 2402783. That is People of the State of Michigan versus Talesia Williams. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Yang,
Good morning, Your Honor. Joseph Yang on behalf of Ms. Williams, who is present to my right.
and ma'am, you are Talesia Williams, is that correct?
Yes.
All right, thank you. This is the time set for a preliminary examination. Ms. Wilson, how we proceed?
Thank you, Your Honor. I've checked the hallway twice. My complaining witness is not present here today. Our office has not tried to contact him outside of sending the subpoena because he was just a defendant before this court a couple months ago on a case that was dismissed without prejudice, and because of the intertwining incidents with this case, I didn't want to reach out to him outside of the court. Nevertheless, he is not here today. I'm not surprised. He didn't really want to call the police to begin with. So I don't think he's going to be cooperative. Additionally, the officer that was subpoenaed is not present here today. I do not know why. I have not been told that she wasn't going to be here today, so I have no reason for her absence. So people cannot proceed.
All right, thank you. Mr. Yang.
Defense with a motion for a dismissal without prejudice.
All right. Based on the prosecutor's inability to proceed, there was a subpoena sent to the individual on this case. The officer, we have not heard from the officer. People are unable to proceed without the complaining victims answering the subpoena, or at least some conversation with the complaining victim, and therefore this is dismissed on defendant's motion without prejudice. And we'll print that out. Ms. Williams, what that means is the people could reissue if they choose to, but realistically, for our purposes today, the case is dismissed, all right? And I would wait about a day to let the system purge you, because it's all on computer for your pretrial conditions. You should wait about a day to make sure that those are all purged from the system or else, they'll be arresting you on something that's not in the system, okay? Or that's attempting to leave the system. I mean,
Oh,
I may have printed one of them.
I think so.
I heard it
Well, there's
twice.
four
Well, there's a
counts.
bunch of counts.
Yeah, so.
Yeah, so it's 2 pages.
All
Okay,
right.
I couldn't,
All right, so I am in possession of the Nolly Prosser order of dismissal made by the defense and there's on 4 counts of this. I will sign that. Anything else for the record in 2402-783, Ms. Wilson?
Is she on a tether?
I think she's on 10.
Yeah, so if we can get email to JSG.
Yeah, so we'll email JSG, but it'll, just make sure it takes about a day, okay? Mr. Yang, anything else on 2402-783?
Nothing from the defense, Your Honor.
All right, Ms. Williams, you're all set. Thank you for your appearance today. Thank you, Mr. Yang. You're all set.
Your Honor.
And it's all civil this afternoon.
Yep.
What's that?
Unfortunate.
It's all brand new civil too, at least for a couple, it's all brand new, which is all right. It's not 76,000, let's
Yes.
half of 76 is like 37, 38, yeah, yep. So we're good to go, pretty much. How does prelim day look tomorrow?
Not great.
Is anything running? You didn't send your email like.
I
She's
have
probably
not been
waiting.
able to yet.
Yeah.
I know a few are not. I know Adam is doing one, so.
Adding charges.
Yeah.
But he knows we do an over/under on adding charges for him.
Yep.
So,
It's expected.
well, his problem is whether his victim's going to show up.
Yeah,
on many of them.
and I
But
don't
he
think
does-
I don't think it's one that he can do victimless.
Yeah. Yeah,
We're not
that statute is pretty.
She's appeared twice. But last time she indicated that she was pretty frustrated that she
Hello?
Hello?
Oh, sorry about that. Am I in the right place?
I guess I don't know who you are or why you're here because I'm not court personnel, but actually another Zoom participant.
My name is Sharon Vaughn, and I have a court meeting today at 1:30 with Flores.
Then I think you're in the right place because I have a 1:30 appointment with Judge Flores as well.
Yep.
And I see that Ms. Vaughn is here, so.
Okay.
Are you Ms. Vaughn?
Yes.
Oh, hello, Bill
Yeah.
Sil- I'm on Discover Bank.
Okay. Can
Um,
you see me?
I can't, no, you have to
Oh,
put your camera on.
I don't know what.
There should
Okay.
be like a button you
Okay, here
can
we go.
press. Yeah, to click. It looks like a movie camera.
Okay.
There you are.
There
Hello.
you are. Okay. I ain't
Um,
too good with this Zoom stuff. I don't do this
oh,
too.
that's okay. No problem. Did you want to talk about the case? Do you want them to put us in a breakout room where we can discuss it?
Yeah. Yep.
Okay, maybe they can do that.
Okay.
Is there a court clerk that can hear me? I guess not. Well, what I can tell you, no, everyone can hear us. I'll wait till it's more private conversation. You probably don't care to discuss it in court.
Okay.
I was going to tell you, a lump sum possibility, but I'll wait until they put us in what they call a breakout room where no one else can hear the
Yeah.
conversation.
Well, she gave me three options, and
Oh, someone from
I
our
would
office?
from the last court date. She gave me three options, and I just neither one of them are feasible for me.
Okay. One of them might have been a lump sum payment where we could reduce it to 66% if you do. And that
Yeah.
was gonna be one of my options. And okay, so I guess we don't need the breakout room if it's not feasible, but do you dispute the debt or is it more a matter of how you're able to pay the debt?
It's not a dispute, but they want me like to pay it all in 2 years, and
Yeah,
like I
that's
said,
always what they want.
I'm on disability. I'm totally and permanently disabled right now, so I'm not
I'm sorry
working,
to
and
hear that. You're not working, right?
yeah, I'm not working. I haven't
Okay,
worked
just received
5 years.
disability. I'll
Yeah.
make a note of that in the file. On disability,
Yep.
is that through the state or private?
Nope, through the state.
Okay. Okay, well, we don't have it resolved today, but hopefully we'll be able to work something out. And you have their number. You can always call them and see if they can agree to
Yeah,
something
I
you can.
sent the letter in, and they said, well, I know they're not going to take that. So I went up a little bit more. But it's like they want this paid off in 2 years. I mean, like, even if I was paying the minimum payment every month, it still wouldn't be paid off in 2 years. So
Yeah.
now they just want it all at one time. I don't have, I am struggling so bad right now. I had to sell my car to not go into foreclosure, and they're going to raise my mortgage again this year. I'm going to have to come out of this house. I just can't afford it anymore because it's $900. I only get 1,500 a month. So
I understand.
everything is I did my whole monthly bills and everything. I come up $258.32 short, and that's not even including food, transportation, or personals. Those are just bills. I've cut everything I could possibly cut, and I'm just paying the bare minimums, and I'm still struggling. So I'm a month behind on my
I
mortgage.
understand. I understand. You don't have to explain it. I get it. Yeah, well, we'll just wait for the judge to call the case. When he does, we can let the court know we don't have it settled and see if the court will probably do what they call a scheduling order. Other dates,
Okay.
Excuse me.
Hello?
Hi, you're
Yeah.
both live in the courtroom. Would you like a breakout room?
Oh, no, we wanted one earlier, but no one was here to give it to us. But now we've discussed it. So no, we don't need one. Thank you.
Okay, if you could please mute yourselves until your case is called, though.
Of course, of course.
Thank you.
Oh my God.
You're getting something out of it. You're getting it. Got me a hold again. That's a princess. Ooh, look at this big old boy. Big old boy, look at those pretty eyes.
Sharon, you haven't muted yourself. If you're gonna have conversations, you need to mute yourself. Now you have. Okay, you're good.
before they start.
All right, good afternoon. Mr. Saloom, are you ready for Discover Bank versus Sharon Vaughn? And Mr. Vaughn, Ms. Vaughn, you're here on that case. I just want to make sure Mr. Saloom's not in another hearing.
Can you hear me?
I can, thank you, ma'am.
Oh, okay. I did.
I can, and I'm wondering if Mr. Saloom's in another hearing for Discover Bank. So, oh, there he is. All right, so we're on the record in docket 24-03-3261. That is Discover Bank versus Sharon Vaughn. Will the parties please introduce themselves for the record? Mr. Saloom.
I'm sorry, Your Honor, my volume was off. I don't know if the court indicated anything. I apologize.
You're fine. Just appearances for the record.
William Saloom, P 41487, appearing on behalf of the plaintiff, Your Honor.
All right, and Ms. Vaughn, you are Sharon Vaughn, is that correct?
Yes.
All right, and you can hear me all right, Ms. Vaughn?
Yes.
All right, this is the time set for a pretrial in the matter. I don't know if the parties have had the opportunity to speak on this matter. I generally allow the parties, if they're amenable, to speak on the pretrial. We have Mr. Saloom from Discover Bank here, and he could file a discovery pretrial, or we can do one here, and the court can do one. But if the parties are amenable, I can put them in a breakout room so they can discuss about some of the legal issues.
Your Honor,
so Mr. Saloom, I'll leave it up to you.
Yeah, we actually did speak to each other.
Perfect.
Before the hearing date. So kind of just trying to, it's a matter of trying to work out a payment. So I guess if the court wants to do a scheduling order, and we can kind of go from there.
I think so. Let's do that, and I think we've got one ready. Let's. So, in my understanding, this is for our. Are you looking at discovery 60 to 90 days out?
Plaintiff doesn't really need discovery, but defendant may want discovery, Your Honor. So
all right.
Whatever the court think appropriate, whether it's 60.
All right.
We have no objection.
I'm going to put it in the 60-day. Of course, you can. And then the other is that I would anticipate at some point that you want to hold in, you want to hold back, or you want to anticipate a motion for summary disposition. Is that a fair statement, Mr. Saloom?
It's fair based upon the answer received. That's a very
all
fair
right,
statement, Your Honor.
And then we'd also hold back. We'll hold the response. Let me print that order out, and then we'll put it on the record. All right.
All right. Thank you, Your Honor.
Okay. Thank you. And then Ms. Vaughn, we'll put it on the record, and then you can indicate if you want me to add anything to it. But let me print it out. All right.
Okay.
I have to change a few things to take a look at it.
All right. I'm in possession of the pretrial statement in case 24-03-261. Pretrial was held on today's date. Discovery Bank versus Sharon Vaughn. This is a creditor-debtor relationship. We do not anticipate any pleadings yet in the matter. Any possible motions would be an anticipated motion for summary disposition and response. The admission of fact consolidation exhibits are not applicable this time till discovery set in. Discovery set out for 60 days to December 23rd, 2024. And that the parties can work within that time limit, and then let us know if you need further time. I placed on expert witnesses and joinder of claims that the and let's put damages is not applicable. Yeah, so NA on expert witnesses, damages, and joinder of claims. This is a bench trial at this time, unless either party indicates for the record that they have paid for a jury trial fee. I don't believe that's the case from either party at this point. Possibility of settlement is negotiations are to continue. Is there anything else you wanted to place on the pretrial statement, Mr. Saloom?
No, Your Honor. Do we have a return date?
We can set a control date just so we can set it out. And what's the time frame are we looking at?
Whatever is appropriate for the court, Your Honor, and whatever.
All right, we can use the cutoff date for discovery as a return date. That's 60 days out.
Oh, that'd be fine, Your Honor. Yeah, December
Right.
23rd.
So let's set it. So do you want to put it? Let me get a control date time because that's the discovery date. But we can put the control date at sometime around the 60-day mark. Yeah, I would think. Let's go after the New Year so we don't get into the Christmas and the holiday rush. So we'll set a control date for, and I'll write that on here. Yeah, so we'll put other control date set for.
Let's do Monday, January 6th at 2:30.
Monday, January 6th at 2:30 for the control date. I'm going to indicate no, the case was not set for evaluation or mediation at this time. And then, Mr. Saloom, do I have your authority to sign this on your behalf via Zoom?
You do, Your Honor.
And then, Ms. Vaughn, do I have your authority to sign this via Zoom on your behalf? We set a control date for January 6th at 2:30,
Okay,
and we've
what-
set.
I'm
What's
not
that?
really sure, what does control date mean? I'm not
That's
really
only
sure what.
for a
this-
time that we come back and meet
Okay.
to make sure that this is all settled. And we've set
Okay.
that for January 6th at 2:30. And then
Okay.
the discovery is set up for 12/23.
12/23.
Yeah, and that's for the parties to exchange information,
Okay, on 12/23. Okay.
right? But the bigger date, I think, is that January 6th date.
Okay, so we would be back here, the same Zoom, everything on 12/23.
Same Zoom, same way you are right now, June 6th at 2:30.
Okay.
Thank you very much, Your Honor.
Okay, what
All right.
time is the 12/23 one?
Oh,
It
no,
is, that's only a cutoff date for discovery. It doesn't have an
Oh.
actual hearing date.
Sharon, if
Oh,
you have any questions from our office, you would want to present those to us in writing before
Okay.
December 23rd. That's what that date's about.
Oh, okay, okay,
It's just
yep,
a
I
date
can
for
do
your,
that.
yeah.
Right.
If you have any issues.
And then, Ms. Vaughn, do I have authority to sign that on your behalf?
Yes, sir.
All right, I will sign this. And then each party should get a copy of the pretrial statement at your last known address with the court. Anything else for the record in 2403-261, Mr. Saloom?
No, Your Honor. Thank you very much.
All right. Ms. Vaughn, do you have any questions of me?
No, sir.
Okay, you should be all set. We'll scan it into the computer and then we'll get a copy sent to each one of you. Thank you for your appearance today.
Thank you, Your
Okay.
Honor. Ms. Vaughn,
Thank
have a
you.
good day. Your Honor, have a good day.
Thank you, you too.
Thank you.
Yep. Bye-bye.
because nobody came on the motion. Unless they withdrew the motion or he just lost, they don't know, they just lost the paper. And then the 2 o'clock's the one that we finished up yesterday, right?
Yes.
Fully recovery.
Yes.
And sir, what case are you here on?
Amir Abdullah.
Okay, that's the LABNB funding versus Amir Abdullah. Ms. Popoff was on that case?
I don't know. I'm not a lawyer. I'm the interpreter.
Oh, you're just the interpreter on that?
Yeah.
So you're here for Mr. Abdullah?
Yes, sir.
Gotcha. What is your name?
Edward.
Edward.
Last name E.
All right. Let's see if Mr. Abdullah shows up. And then, and if LVNB funding shows up, they should be here in the next 15, 20 minutes, or else something's wrong. So this is- Then we have Bank of America too. Southwood. Yeah. Well, parties on the
Yes.
on that 4377. South. All right, and Ms. Notice Hartman, what case are you here on?
Hey, Judge, I've got LVNV versus Amir Abdullah.
All right, we have LBNV funding is here. And Edward, you are here on as an interpreter for Amir Abdullah. All right, give me 1 second. And then Miss, notice we have an interpreter here on that case. I'm going to call that in about 2 minutes.
Okay.
All right, Mr. Edward, I'm going to have you please state and spell your first name and last name for the record. So go ahead, sir. You should, yeah.
Edward Eid, interpreter.
Okay, and spell your first name and last name.
EDWARD, last name EID.
EID. Okay, please raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and partially interpret in the matter now before the court and not divulge communications under the penalty of perjury?
I do.
All right, thank you. So I'll call the case, and then if you need for me to slow down, just tell me, all right? Because I'm afraid we get going too fast for that. So, all right, so we're on the record in 2405214 GC. And that is LBNB Funding LLC versus Amir Abdullah. Will the parties please introduce themselves for the record from LBNB Funding?
Good afternoon, Your Honor. Attorney Ashley Nonis Hartman on behalf of plaintiff.
All right, and sir, you are Amir Abdullah?
Yes.
Thank you. This is the time set for a pretrial in the matter. Go ahead. And Miss Notice Hartman, first of all, we can do a pretrial statement for this case, but would you like the opportunity to speak with Mr. Abdullah and the interpreter? We can place it, go ahead. Since we have the interpreter here, we could place everybody on an iPad, give you a little privacy, and then have an actual pretrial where some communication is going on.
Your Honor, I would like to postpone this. I'm sick and I'm taking medication.
Medication make me dizzy. This medication because I'm exercise.
Oh.
Yeah, because
I'm gonna be very busy at the upcoming 2 months visiting doctors and going through scanning and screening. And there's gonna be an MRI done to my head.
Because I'm dizzy.
I feel dizzy and I get dizzy all the time.
Yeah, you can push it into January.
If we're here
into January.
All right. If we're here, I don't want to postpone it because you're already here, and I don't want to adjourn it into January because that's 3 months away.
بما انك هون ما راح اجلها وكمان ما بدي اعملها بشهر واحد لما 3 اشهر.
let, at least we can do something at the pretrial to see if we can get the case moving.
هاي هلا هو دائما المنطقه الاول هذا بيكون الفكره يعني او المحاكمه فعشان هيك نشوف انه اذا نقدر نحدد شيء من الموضوع هذا وبعدين نشوف المساعدة.
You can indicate that this is a pretrial, so we're probably going to adjourn for order of the court for discovery purposes 60 days out anyway, which will put us into January or late December.
هلا هاي في ابتدائيه ولكن بعدين المحكمه يطلع على الادله وكل شيء ويصير في تحريات او انه يجيب دراسه تفاصيل هذا يمكن ياخذ 60 يوم يعني انه محكمه مده شهر.
Is that a fair statement, Ms. Nonis Hartman?
Yes, but Judge, I think to move it along, we could ask a couple questions based on his answer.
But would you be amenable to meeting for pretrial purposes with the interpreter in a breakout room?
No, that'd be fine.
Okay, that might facilitate some communication, and that would be valid use of the interpreter for today's hearing. All right, so let's do this. My court officer will put you on an iPad, both of you, and then I'll place you in a breakout room to speak with Miss Nonis Hartman. So follow her when at her direction, okay?
عشان تحطها الكمبيوتر معاهم وتحدث معاهم.
All right, and Miss Nonis Hartman, I'm going to place you in a breakout room.
Okay.
And then we'll come back and put it on the record, and I'm going to place you in room 1.
Okay.
So you should get a prompt to go to room 1.
Okay.
Mr. Sarhan, you're on 242854. You're on the Bank of America case?
Good afternoon, Your Honor. It is, yes, a Bank of America case.
All right. I think Miss Zacharias just joined us.
Fantastic.
And then once we get everybody here, we'll call that case.
Great. Thank you, Your Honor.
You're welcome.
Good afternoon, Diane.
All right. All right. Let me find that. That's 5214. All right. So we're on the record in docket. I'm sorry. It's 285. It's the previous one. All right, we're on the record in docket 24-02854. That is Bank of America versus Tishta Church. Will the parties please introduce themselves for the record? Mr. Sarhan.
Good afternoon, Your Honor. Alexander Sarhan, P77252 on behalf of plaintiff.
All right, and Ms. Zagreis?
Good afternoon, Diana Xagaras on behalf of the defendant, P32106.
All right, and did you expect Miss Church to be here, ma'am?
No.
No, okay, all right. This the time set. I looked at the note, I looked at my notes in this, and this was set, I think we set this for a control date. Oh, I didn't, okay. So this is set for pretrial in the matter. Since we have two attorneys on this, I could put you in a breakout room and have you speak about the case and some of the conditions that led to the filing of this case. If you're both amenable, if you want, you can trade to do a pretrial discovery sheet on your own, or I can fill out a pretrial discovery sheet and get authorization to sign that by half the parties. It's really up to you how you want to proceed on the pretrial.
Your Honor, if I may, if you could put counsel and I in a brief breakout room. I do believe this matter is resolved, and we've sent sister counsel some paperwork. So we may be able to get this on the record and e-file today with just a brief conversation.
All right. So, Ms. Zagreis, would you be amenable to meeting with Mr. Sarhan in a breakout room?
Sure.
All right. I'm going to place, so Mr. Sarhan, I'll place you in room 2. And Ms. Zagreis, I'll also place you in room 2, and then we can come back and put it on the record.
Okay.
All right, so we're back on the record in docket 24-05214. And Ms. Monis Hartman, did you have the opportunity to speak with Mr. Abdullah in a breakout room with the interpreter?
Did.
And what, if anything, came out of that meeting?
Nothing beneficial. It seems that the defendant, based on his answer, is still planning to file bankruptcy. We will definitely need discovery. I intend on doing discovery and then filing a motion for summary. So I would request, like the court stated, at least 60 days of discovery with a motion date to follow.
All right, go ahead. So I will set discovery at 60 days out. That'll be the cutoff date for discovery. And then you do plan on filing a motion for summary disposition, and we'll await the response.
Oh, yep.
All right, let me get that printed, and I'm gonna have a pretrial statement to that effect, and then I'll place it on the record. All right, so I'm in possession of a pretrial statement for docket 24-05214. That's LVNV Funding LLC versus Amir Abdullah. The pretrial conference was held on October 24th, 2024. Appearing for plaintiff was Ashley, known as Hartman, and for defendant was Amir Abdullah. The issues concerning legal issues here is a creditor-debtor relationship. Okay, the pleadings are not anticipated at this, any additional pleadings are not anticipated. There is a possibility of motion for summary disposition or motion for summary disposition and response. And that's to be filed and heard by December 23rd, 2024. There's no consolidation date. Because there's no, it's not applicable for the admission of fact or exhibits. Set discovery for 60 days for December 23rd at 2024.
Judge, just a quick question.
Sure.
You had stated that the MSD, the motion for summary hearing date would be the 23rd. Can I ask
That's
that
the
it's
cut. It has to be filed by the 60 day.
okay, because the only thing that I'm worried about is that if the defendant takes time and doesn't submit responses in time or waits for his discovery until the 23rd, that leaves us in a little bit of a conundrum whether or not to file the motion. So could we have a motion date maybe like 2 weeks after the cutoff of discovery?
Absolutely. So let's get that interpreted. So let's go 2 weeks after December 23rd for the motion to be filed. That'll post date the discovery process. January 6th. At what time? No, that's fine.
I was just thinking.
Yeah.
I
So we've changed the motion for summary disposition to be after discovery for January 6th, 2025. And Mr. Abdullah, we did that so you'd have enough chance to respond to the motion for summary disposition if need be. If the motion files, it'll be filed by Ms. Nonis and Hartman, and they'll be filed to the court.
توصل مراتبين اخوات الجو ومعك الجو فعشان هيك في 6 جانوري 6
January 6th, 2025.
25 عندك النتيجة ونشوف شو اللي صار هناك وشو
All right, so I placed NA on expert witnesses, damages and joinder of claims. The nature of the trial is a bench trial.
Yes.
So that would. All right. And negotiations may continue on this case. This will not be set for case evaluation. And this will not be set for mediation. Unless the parties request. So I'm in possession of the pretrial statement. Miss Notice Hartman, do you give authority for me to sign it based on what's placed on the record?
Yes, Judge.
And then Mr. Abdullah, based on what we placed on the record, and you'll receive a copy of this, do you give your authority for me to sign this? Actually, Megan, he can sign this because he's here. I got caught up in the Zoom, but he's right here.
You did that the other day, but I didn't want to say anything.
It's so true. So here, you can give him the pen and he can sign it and take a look at it and have anything explained to him.
إذا موافق هاي هون شايف واحد ثاني damages وفي تعويضات nature okay yeah okay and that's fine yeah.
Thank you, Megan. All right, I will sign this in the judge's placement. So Ms. Notice Hartman, my court, after we sign and scan it, will send a copy to your law firm, the last known address. And Mr. Abdullah, I will give you a copy today. All right. All right. Anything else for the record for the pretrial on 24-05214, Ms. Notice Hartman?
No, Judge.
All right. Mr. Abdullah, do you have any questions of me? All right. All right.
He's saying that he told us that he didn't never receive that card.
All right. Yeah, this is a pretrial statement for the kind of the dispute. If you're able to work it out, fine. If not, you'll entertain a motion for summary disposition probably in January. All right. So make sure you get a copy, and that's all for the record in that file. Thank you for your appearance today. You're all set.
Have a good day.
You too.
Yeah.
All right, the Zoom user, are you here for Southwood Financial? Would you identify yourself, sir? You have to unmute. There you go. And what's your name, sir?
Oh, if you're talking to me, I'm Gary Strauss. I'm for Robert Ash, the Capital One versus
All
Robert
right,
Ash.
so, all right, we don't have a representative from Capital One here, but Mr. Ash, it's my understanding that you've already filed a pretrial statement with Mr. Duquette. Is that a fair statement?
Yeah, for Mr. Ash. Yeah, I'm Gary Strauss. Yes, Your Honor.
All right.
Or
Yeah, so we've got a pretrial statement filed by yourself, yourself for Mr. Ash, and we have one for Mr. Duquette on behalf of Capital One. So if you just stand by for a few minutes, we'll see. I will see if Capital One shows up, but we already have the pretrial statements already filed in this.
okay, I'll just hang on then. Okay.
All right. Yeah. I mean, I'm what I'm afraid of is that they'll show up and then I'll let you go. But it appears that we've already got what we need. The pretrial statement's already been filed, and I'll call another case in the meantime.
Okay, I kind of thought that, but I didn't see that written down anywhere. All right, I'll just hang on for now. I'll put myself on mute. I'll put myself on mute until I hear from you.
All right. Thank you.
Thanks. Thank you.
All right. So let's go on 2854. All right, so we're back on the record in 2402-854. It's Bank of America versus Tisha Church. And Mr. Sarhan, did you have the opportunity to speak with Ms. Zacharias in a breakout room?
Yes, Your Honor, we did. The defendant in this matter is enrolled with a debt management company that Ms. Zacharias often works with. So this was resolved a few months ago, and the defendant has been paying on it. So we do have a stipulated order for conditional dismissal reflecting that original agreement. Diane has signed it and emailed it back to me. So I'm prepared to e-file it, Your Honor, once we conclude.
All right, so there is a order of agreement for conditional dismissal.
That's correct.
Dismissal, and you'll follow that up with an order.
That's correct, Your Honor.
Okay.
It'll be filed before the end of the day.
Okay. All right. I didn't have that we previously met on this, but it appears that this was scheduled by the civil department. But if you followed up with an order, we should be all set, Mr. Sarhan.
All right, great. Thank you, Your Honor. Thank you, Diane.
Thank you, John. Anything else, Mr. Grice? Or you're all set. Thank you for your appearance today.
Bye now.
Thank you. Oh, whoops.
Most valuable horse I have right there. I'll show you why.
Let's go ahead and mute her. All right, so Mr. Best, I'm sorry, it's Mr. Strauss. Mr. Strauss, you can unmute.
Okay.
All right, so we did just check again, and we have both parties filing a pretrial statement on October 16th. So this may have been scheduled in error, I'm not sure, but it appears everybody's done what they're supposed to do.
Okay, and hopefully we'll have it settled soon. I'm hopeful we'll get this together pretty soon.
All right, both pretrial statements were scheduled were filed on October 16th.
Okay, great.
All right, you're all set. Thank you for your appearance today.
Okay, thanks.
All right, so we're on the record in 24-04377. That is Southwood Financial versus Francesca Wojda and Wojda Diane Hernandez. Will the parties please introduce themselves for the record from Southwood Financial?
Yes, good afternoon, Your Honor. Stuart Best of the firm of Waltman, Weinberg, and Reese on behalf of the plaintiff, counter defendant.
Good afternoon, everybody. My name is Daniel Finley. I appear before you today on behalf of Diane Woduk, who is present on the screen.
All right. So we have Diane Wojda, Mr. Finley's, and there's a Francesca Wojda. Mr. Finley, you also represent Francesca?
Yes, Your Honor, that is correct.
All right. And then we have a counterclaim, and it's the same parties on the counterclaim. Is that correct?
Yes.
All right. All right, this is the time set for a pretrial in the matter. And so this is how we generally do pretrials. These all parties. I have that we previously met and you filled out a pretrial statement. but I don't think that's the note on this file. Is that correct? Because I don't think you previously met on this case.
That is correct.
All right, so I'm gonna indicate that's disregarded. That's note. All right. All right, so we have two attorneys involved. First off, at the pretrial, I will allow, if amenable, both parties can meet in a breakout room. I can place you in a breakout room. You can discuss some of the legal issues that led to the filing of this complaint. That's the first thing we do. Second is, since Mr. Best and Mr. Finley, you're on this case, you can both file a pretrial statement that you agree upon as attorneys of the court concerning discovery orders and things of that nature. You can do that, and as long as you both review it and advance it to the court, that's fine. Or I can do an order myself. I'll print out an order. Generally, I set a discovery period, and then anticipated motions, responses. But since we have lawyers on the case, that might be better left for you to do. Mr. Best, do you have a preference? Would you like to meet with Mr. Finley, discuss some of these matters?
Yeah, let's take a few moments. Would be a good idea.
Mr. Finley, would you be amenable to meeting with Mr. Best in a breakout room?
Of course, Your Honor.
All right. So Mr. Best, I will place you in room 1. You should get a prompt to go to room 1. Mr. Finley, you'll also get a prompt to go room 1, and then we'll come back and put it on the record, okay?
Sounds good.
All right. Mr. Finley.
Your Honor, if you're not on the record, we have a discussion to the court.
All right, give me 1 minute. We're working on another matter, and then we're going to place your matter on the record.
I hope the court got my chat. I'm also on another matter for Cap One in this court this afternoon.
All right.
Your Honor, may we have a breakout room with my client and I briefly?
All right, so we're back on the record in docket 24044377. That is Southwood Financial versus Francesca Wojda and Diane Hernandez Wojda. Mr. Best, did you have the opportunity to speak with Mr. Finley in a breakout room?
Yes, we did, Your Honor. In fact, Mr. Finley would like to have a moment with his client in a breakout room. That's what we came back in here. So if he can have an opportunity.
So Mr. Finley wants to speak with his client concerning that? All right. All right. So Mr. Finley, I'm going to have you placed in room 2. And Ms. Wojda, I'll also have you placed in room 2 with Mr. Finley, and then we can come back and put it on the record.
Yes, Your Honor.
Thank you.
Yeah, I don't see brother counsel, my other matter. I'm not sure someone else is covering for them.
Yeah, if you need to go to another courtroom and come back, that's fine.
Oh, no, I'm in this court.
Okay, all right.
Good luck with
She
you.
said we would have canceled the warrant and gave him an arraignment date.
We're just trying to figure out if we're going to arraign somebody in the next 10 minutes. We're getting distracted, but we'll await the parties to come back from the breakout room, Mr. Finley and his client.
Okay, and then is there anybody here on Cap One versus Robert Ash? Anybody sign in for that one? That was also a 3 o'clock.
There was Mr. Strauss was here on Capital One versus Robert Ash, and It appeared that everybody had filed a pretrial statement on October 16th, so we just let everybody go.
All right, sounds perfect. Thank you. I'll put that.
All right, thank you.
I'll sit back. Stick around for the arraignment if it sounds fun.
Not any fun, just trying to figure out what we're doing.
Sounds good.
Thanks.
I'll be quietly. Thank you.
2269. That is people of the state of Michigan versus Michael Brayton. This is the time set for an arraignment in the matter. You're being arraigned on the allegation today that we were all a part of, that you failed to appear at 9. This was set for 9 o'clock, and then at 10 o'clock you were not here. You failed to appear for your sentencing today. So you understand the nature of why the bench warrant was issued for you?
Yeah, I
Okay.
do.
All right.
But I was late.
What's that?
But I wasn't here at the time. That's
All
what
right.
I don't understand
Well,
why.
I'm going to remand you to the Ingham County Jail into custody until we get a sentencing date. And we've got a sentencing date now.
I gotta go to jail then?
You've got to go to jail today.
Can I do something first?
No, you're going to jail because I can't find you.
I can't. I gotta do something real quick. please.
No, you don't get to do anything today but go to jail. All right? So your sentencing date is set for November 1st at 9 o'clock.
When?
You missed your sentencing this morning. Your sentencing date is set for November 1st at 9 o'clock, and you're remanded to Ingham County Jail for your sentencing date that you should have got this morning, because you're going to be sentenced this morning and you failed to appear. All right. So thank you for your appearance today. You're all set.
What date is it?
November 1st at 9 o'clock.
I'm fixing something and I'll have it printed for you.
How many days did I wait?
It's a week from today. You're a week from today remanded for your sentencing.
You sure? I didn't realize it was gonna be that quick, Judge.
Very
I wasn't even done filling out the sheet yet.
All right, so let's go back on the record in docket 2404377. This is, so Mr. Finley, did you have the opportunity to speak with your client in a breakout room?
Yes, Your Honor, and I believe we have a resolution, if I could just inform.
All right. Did you want to go ahead and place any terms on the record? And then I don't know which party is going to follow it up with an order, but certainly you can place any terms on the record.
Thank you, Your Honor, if I may. The counterclaim will be dismissed with prejudice. A consent judgment will be entered for the full amount of the claim on plaintiff's lawsuit. I will follow up with brother counsel to see if we can come to an agreement as to payments. And if not, it is the intention of these defendants to file a motion for an installment payment order if we're not able to both agree as to what these ladies can pay towards the judgment.
So my understanding, and Mr. Weltman, correct me if I'm wrong, there is going to be, this is a consent judgment with the terms to be placed, orders to follow. And then if you're not able to agree on the terms, what's going to happen, Mr. Finley? I missed that.
Oh, I apologize, Your Honor. What would happen if the parties are not able to come to a consent agreement as to payment amount? The defendants would then file a motion for an installment payment order before Your Honor and request an amount.
All right. Is that a fair statement, Mr. Weltman?
I'd love to be Mr. Weltman. I am a
all right. I'm sorry.
It's okay. No problem.
It's Mr. Best, correct?
No problem. Yeah, just to keep the timeline complete, I recommend, we didn't talk about this, but brother counsel and I probably worked this out. If we can get our consent judgment entered today for the full amount, obviously we can't take any collection activity for 21 days. So I would say we will not, let's round it off to 30. We won't do anything for 30 days. And at that point, that gives him an opportunity in which to file a motion if we can't come to a resolution within 30 days.
All right. I can also set this for a control date out for 30 days if that would help.
Well, we'd like to get that consent judgment in that way.
All right.
Yeah. That
all right.
way,
So I'll await the order to follow, and then you can wait the 21 days and file your motion. But I will wait the consent judgment to follow for the court's signature. Anything else for the record in docket 2404377, Mr. Finley?
No, Your Honor.
Mr. Best?
Yep, nothing further, Your Honor. We'll present an order.
All right. Thank you for your appearance today. You should be all set.
Great. Thank you.
Thank you. Have a good day, everybody.
You too.
Thank you.